Good evening and welcome. Welcome to LawLine. I'm B.J. Krinsman. I'm an attorney, and I have a general practice in Newton. And tonight is the premiere of our 15th season, so welcome, Newton. And you might have noticed on the graphics, we are now the award-winning LawLine. We won a couple of awards last year, so we're thrilled to be back. And I don't know how we're starting off the season either on a high note or a low note, depending on how you want to look at this. Because the topic is divorce, so that's a little bit the low note. But the high note is we have a star-studded panel for you. This is going to be a fabulous show. With us, I'll introduce them closest to me, and then we'll go down the line. We have three guests tonight because it's sort of a topic that has three sections to it, so we've got three experts with us. On my immediate left is the Honorable David Kopelman. David is a retired, he was the presiding judge in the Norfolk Probate and Family Court. And do you have any idea how many divorces you oversaw? 80 million? Thousands and thousands. He retired and took the high road and is now a divorce mediator. So we're going to hear about divorce mediation from the Honorable David Kopelman. David, thanks for coming on.
My pleasure.
To his left is Charlene Caldeira, and Charlene is a divorce attorney, and she's going to talk more about the traditional route that we go for divorces. And she's with the Newton law firm of Rosenberg, Friedman, and Goldstein. And to her left is Goldstein. So we have Howie, well known to in Newton and in political circles and in legal circles. We've got Howard Goldstein, and he is, as I said, the Goldstein of Rosenberg, Friedman, and Goldstein. And thanks for coming with us. And he's going to talk a little bit about collaborative law tonight. So thank you all. And I think we're going to begin with you, Charlene, which is I want to talk a little bit about the, sort of as to set the stage for this, the traditional divorce route. And by the way, as I said, we're going to talk about traditional divorces, collaborative law, and mediation, all in divorce. If you have any questions for the panel of experts, the number to call is 617-795-2540. So if you have a question, get your finger ready to press. Charlene, yes. Tell us about divorce. I think we wanted to set this up first by talking about there are two ways you can actually initiate a divorce. There are two different kinds of petitions that you can file. Yes. Do you want to tell us a little bit about that?
How I normally explain it to my clients so that it's easily understandable in the sense of layperson's terms is that you can file pursuant to 1A, which is what I call quick and easy joint petition. And that's where the parties have already reached an agreement on all of the terms themselves. And they can do that with or without attorneys, but that's something that can be done relatively quickly. The other route is the 1B route, which is the typical, what most people would think of as the complaint for divorce.
Right. And in the 1B, this is somebody is served with what we call divorce papers, which is a complaint for divorce. They haven't agreed on everything. They may have agreed on some things, but they haven't agreed on everything. And so someone starts the process. And what are the issues that have to be settled in order to actually get divorced in Massachusetts?
I mean, essentially all of the issues need to be resolved, but the way I like to explain it is the major components. You've got property division, that's going to deal with the disposition of property. You've got support, and that includes child support as well as alimony, and that obviously depends upon the facts of the case. And then you've got custody, and that also involves a determination of legal custody as well as physical custody.
Okay. And we now have two, well, they're adversaries because they're in an adversarial procedure. And how long does it, do people ask you how, they call me because a big part of my practice is divorce, probably about 80%, I think. And they call me and say, oh, how long does this take? So, of course, the answer to all legal questions is, it depends, right? But what's your experience with that?
I mean, it depends, and you know that just as well as we all do. It can be anywhere from, if it's a joint petition, it could take a month or 2 or 3 months, or it can take years, 8 months, 1 year. It really depends upon how contentious the case is. And it also depends on some of these other methods of resolving the case.
Right. Howie, I'm going to ask you, what's your world record for how long a divorce case lasted? Do you have a,
Well, I just finished one that was at least 5 or 6 years old, and from beginning to end, I had one couple that was actually separated for something like 7 or 8 years before they got to the lawyers. I don't think
Oh, I know.
that's that unusual.
No.
So it can go on for a very long time.
I actually had a woman whose husband had moved out 10 years before she came to me. And then after she came to me, it was another 3 years before she got it together that we could actually file. I worked with her for 3 years, and then she was ready to file. This is, you know, everybody's different and everybody at their own pace. I've had them go, and you always know they bring down the file, and it's like huge when they send the file down. You can tell how old a case is, and the red jacket gets a little rattier and rattier as it goes along, and you can tell, you know, what's been going on.
Well, then there's
So-
the things that happen after the divorce that cause the file to get even bigger.
That's right. I have one that I call him my annuity. Okay, and you know who you are. You know who you are. You live in Newton. He's my annuity, and it will never, ever end because there's always something going on. So that's the traditional route, and you know, this is, I think, part of the reputation that lawyers can get because they're always the zealous representation, which the other side sees as misrepresentation or an unfair coloring of the facts. But from that, I guess, Howie, you decided to focus a lot of your practice on collaborative law.
Mm-hmm.
And tell us what collaborative law is.
Well, collaborative law arose out of lawyers' unhappiness, really, with the traditional route as well as clients. The idea in collaborative law is that the clients each have lawyers. They have an advocate in the room, but they sign an agreement with their lawyers, and sometimes there are other professionals. The collaboration isn't just the lawyers. It could be mental health people. It could be financial planners. And the idea is we're going to sit and talk and negotiate until we reach an agreement. And that agreement can then be filed as part of the 1A petition.
Okay, so if each of the parties has their own lawyer, and by the way, each has to be a member of the Collaborative Law Council to be, to have a true collaborative law situation going on, correct?
Well, yeah,
Or-
I think many of us have been practicing collaboratively for a long time. Collaborative law as an entity and collaborative practice, as it's now called, because there's more than just lawyers involved,
Right.
is about 10 years old. And in order to practice collaboratively now, you need to be specially trained. There's no requirement that you be a member of the Collaborative Law Council, but most collaboratively trained lawyers do belong to that group.
Right. And I think the point I was trying to focus on was that it has become a term of art now, which is that there were those of us who practiced, you know, the traditional divorce, but we tried to be cooperative. We tried to keep things at some kind of simmered down level. So you could just say, well, let's collaborate on this and try to help this family out. Let's see what we can do for them. As opposed to what collaborative practice now is, which really is a term of art. And tell the kicker, which how you avoid
Right.
Avoid getting into contentious litigation.
Well, as you indicated, clients accuse lawyers, sometimes properly, of making things worse to pad their own pocket and to create hard feeling and therefore more litigation. In the collaborative process, the lawyers sign an agreement that states if the case fails to settle, that the lawyers will withdraw. And what that does is it takes away any incentive that the lawyers have to make things worse.